My name is Jill Coil, and welcome to another episode of No One Dies from Divorce, where we talk the nitty-gritty aspects of divorce and help each other come through this not only surviving, but thriving. I'm a divorce attorney, and I'm interviewing other experts and people just like you who are going through or have been through a divorce, so you can have the latest and greatest information on all things before, during, and after divorce. Let's dive in. Welcome to another episode of No One Dies from Divorce. We are in studio, and I'm so excited for our special guest today, T.R. Morgan. Welcome to the show.
Thanks for having me.
Today we're talking, I think this is going to be a really great episode because TR was formerly Commissioner Morgan, who was, the commissioners are over family courts here in Utah. And so we're really going to be able to ask the questions that I think everybody is thinking from an actual perspective of somebody from the bench. So just so you know, TR currently now works for Coil Law. He stepped down as commissioner in January and now is an integral and really, really important part of what we're doing here at Coil Law. So thanks, TR, for coming on the show.
Thanks. I'm looking forward to it.
So let me just tell you a little bit about TR so you guys know. He grew up in northern Utah playing high school basketball, winning at board games. We always talk about that. And watching TV when he wasn't reading. After serving an LDS mission to Brazil, he attended the University of Utah and graduated with a political science degree. He then went on to receive his Juris Doctorate from the S.J. Quinney School of Law at the U of U. During law school, TR worked full-time with the Internal Revenue Service as a tax examiner and legal intern. I'm so sorry.
Yep. No, it was great.
TR started his legal career working with the renowned Ogden Attorney Bob Echard, right?
Echard, yep.
And after a few years, started his own general law practice. TR has litigation experience in most areas of law, specializing in family law and probate. And then most recently, like I said, he served as the Domestic Relations Commissioner in the Second Judicial District Court. His experience wearing the black robe gave him the opportunity to interact with and guide litigants and attorneys through the Shakespearian tempest that domestic litigation can be, presiding over more than 10,000 hearings. He is most proud of and grateful for the high marks he received from attorneys during his annual review. He's married, 5 children.
5 kids. Yep.
Me and him both have a 4-year-old daughter, so we have that in common. And he enjoys traveling, cheering for the Utes, I'm so sorry, and watching and discussing TV and movies. He's also an avid superhero fan, and not necessarily Marvel, which is what a lot of people would assume. He
Mostly DC.
Mostly DC, yeah.
Yep.
So He has, me and TR have been friends, how long now? I actually think that we had one case before you went on the bench, and so we knew each other just a little bit, but we just became friends with you being on the bench. Yeah. As a litigation attorney in Utah, I just went in front of him so many times. It ended up turning into just a friendship where we had mutual respect for each other, and it was really helpful to have a friend be able to go to talk about, best practices in front of a commissioner and judges in the state of Utah. And I guess that friendship benefited me because now we work together and we get to experience.
We work together. And very few people are able to tell you to chill out. So it worked out great.
It worked out great. Commissioner Morgan was the guy that could tell me that, hey, Jill, you are really passionate in your arguments. Maybe we should, tone it down a little bit. So not many people can tell me what to do.
Right.
So let's talk a little bit about your story, about what made you draw to want to be a member of the bench. Like, what led you in your career to say, okay, this is what I want to do?
Well, it sounds a little bit odd or I don't know. It sounds a little funny, but ever since I was about 5 or 6 years old, I wanted to be an attorney and a judge. Like you mentioned, I liked watching a lot of TV, and as a little kid, maybe I shouldn't have, but I was watching Perry Mason. There was a TV version of The Paper Chase. I watched that. And then as I got a little bit older, into the 80s, LA Law and all that, I just always have wanted to be an attorney. And then, you watch Miracle on 34th Street, and the judge decides that Kris Kringle's Santa Claus. I mean, the judge has the power. So I just have always wanted to kind of be an attorney and a lawyer. And
I don't know if we've ever talked about that backstory, because you know that I have always wanted to be an attorney as well. And it was sold with Perry Mason and LA Law.
Yeah. Well, and most people don't. Like, both of my best friends from high school are both attorneys.
Right.
But never once in high school ever talked about being an attorney.
Mm-hmm.
You know, they both went and did econ majors.
Yeah.
And then one of them now is working for a firm in Vegas doing a lot of HOA type law. The other one, I think right now, he's back in Shanghai working for one of the bigger firms in the world.
Wow.
So,
wow.
Doing international trade. And I'm just doing measly little family law.
Well, and it's kind of funny because I knew I wanted to go to law school right out of high school, and so I did political science as well, because that's what they tell you. Oh, go do political science if you want to go to law school, which is a crock. Don't do political science if you want to go to law school. Yeah. Diversify a little bit.
Go get your technical degree in plumbing, so you have a skill, and then go to law school.
I always said I wish I would have done a business degree with a minor in English. Helped me be a better writer, but then actually learn the art of business. So, but anyway, so you had been practicing for how many years before you applied and got the?
I had been practicing for about 12 years, 12 to 13, and I had just my own firm, my own little shingle, and I was doing pretty much every kind of law, and I was doing a lot of guardian ad litem work, helping kids. And the situation came up where Commissioner Dillon in Farmington was retiring, and I really respected him. My very first hearing in court ever was in front of him.
Right.
And maybe I'll share that in a minute. But and I just thought, you know what, this would be something I think I'd be good at, and applied, and they liked me, and then I got stuck with that whole job.
Yeah. So let's explain a little bit for our listeners, because every state is a little bit different in the way that they approach their family law or their domestic law cases. In Texas, where I'm licensed, they have what's called family courts. So they have specific judges that are appointed to the bench that do just the family law dockets. They are judges, though, in the fact that they oversee. And in Texas, you can do jury trials for family law cases, and so
really,
wow. I know.
I don't know if I'd like that.
Most of the time, we elected not to, because why would you want a jury to determine your fate? But yeah. So in Utah specifically, and I know that this is pretty actually more of a commonality in most states. They have what's called commissioners, and they are not appointed in the same route as a judge, but they're hired as basically with the same inalienable powers, but they are considered commissioners. So
let me correct you a little bit, because the administrative office of the courts would say you're completely wrong on that. They would say the commissioner has no power and no final say on anything, which is actually true. But essentially, the commissioner is a quasi-judicial officer. My wife called it a mini judge, right?
Right.
So really, the commissioners are there to do the ugly, dirty work the judges don't want to do, which is the family law cases, right? And so the job notice came out from the administrative office of the courts, and then you apply. There's kind of like there's a little committee that they form in the district of a couple judges, a couple of attorneys, a couple of just lay individuals. And then they go through the applications, pick 9 or 10 to interview. And then after they interview them, they select 3 that they recommend. Those 3 then go to the entirety of the judges in that district. Then the judges have an interview with those 3, and then they select one that then that name has to go up to the judicial council, the governing body of the administrative office of courts, and then they approve the recommendation, and then that's how you go.
Right.
But the commissioner essentially hears those initial hearings, makes recommendations on how the order should go, what should happen. And then, like for me, and we can talk about this a little bit if you want, but for me, pre-COVID, 96% of my recommendations became the actual ruling of the court because they weren't objected to. No, wait, sorry, 94%. 94% became the ruling because no one objected. If someone objects, then it would go to the judge to review it and see whether I messed up or something. and then they could tweak the judgment, they could reverse it, or they could say, nope, he did it right, and that's the order.
Right. And in Utah, it's really, really, if you want to be a family law attorney in Utah, it's a very, very specific kind of law, because we actually have our own rules of civil procedure that we follow in the family courts that you do not do in the civil courts. So we have to be an additional level of understanding of the rules of evidence and the rules of civil procedure, because we not only have to know, what normal civil litigation attorneys have to know, but then we have our own rules that we have to follow, especially when we're in front of the commissioners. And it's very, very specific in Utah. So that's kind of the difference. And I would call you kind of the gatekeeper. Like every motion, except for a very, very select few, and they're different in every court. It's very, very confusing, but has to go to the commissioner first.
Right. Yeah. Rule 101 of the Utah Rules of Procedures state that really any motion in a family law case would go in front of can go in front of a commissioner, but for 5.
Right.
And those 5 have to go to the judge. And actually 4 of those 5 are so simple that why not just have the commissioner? But it's like waive the 90 days and those kind of things. But yeah, the commissioners really are the gatekeepers to hear those initial filings and pleadings and kind of help the parties move forward in their family law adventure.
Right. So, absolutely. And that's what it was interesting, and why I love this perspective, because as much as you're like, oh, well, a judge is the judge, I mean, the commissioners are the ones really making the decisions and doing what, like I said, 95% of the work on these family law cases. Oh, yeah. And so TR, you are, I think, the best person to kind of give an overall, and I think this can be used in any state you are, right, to really understand the perspective of a commissioner or judge. And mind you, we might interlineate the words today, but there is a difference between a commissioner and a judge. But at the end of the day, a lot of times we are in front of you and you are making decisions regarding these cases. And so we want to kind of talk about, hey, wherever you are in whatever state, there is some general keys advice that you, living on the bench and being there over 10,000 cases, could really give our listeners who are going through a divorce, thinking about a divorce, maybe been through a divorce, to help them be better prepared or understand the court system so that they can, better navigate it a little bit.
Right.
And so that's why I'm really grateful that you are here. So I wanted to talk a little bit about, obviously I want to talk about best practices. And I want you, if there's a story that you have that can come to mind, I really would love to talk a little bit about this, but this can be used for whether I kind of want to talk about best practices for attorneys and best practices for clients.
Sure.
So one of the things I wanted to talk about is like,
well, let me just say real quick that any information I give, I'm not giving any legal advice at all today for anybody. Just best practice is just this is what I liked. I think in general it's what most commissioners like. I can't speak for any other but myself, but I did receive generally always fairly good marks. My scores on my evaluations were above the average, which I take pride in, and so I think I can at least give some ideas to people to think about as they're going through this. Right. And just to know, TR was always, I felt, the fairest, most methodical commissioner on the bench. And even though I'm really grateful he's working with me now, it was hard to see him leave because, he has been a really valuable asset for those clients up in the Second District, which is up north, Davis-Weber County. North of Salt Lake.
Yeah, north of Salt Lake. So, and just so you know, at the end of every podcast, I have a little disclaimer that says I am not giving legal advice.
I'm just making sure.
No, it's good. But our listeners know that this is all general advice, and you can take it for what you want. So let's talk a little bit about, as a commissioner on the bench, how did you prepare for cases?
So generally, because the workload the caseload in front of me is so big. There's just so many cases, so many things to deal with. I had a really hard time preparing any sooner than the day before a hearing. Some commissioners, I don't know how they do it. They're prepping cases a week ahead of time. I could never do that. And so what I would normally do is the day before, when I got done with my hearings and whatnot, I would usually have to kind of take a break. You do hearings all morning, a couple in the afternoon. I couldn't go right back into, okay, let's go look at more hearings. I just want to, I just couldn't do it. And so I would usually just kind of like read something else or take a walk, just kind of purge that day's worth of information and whatnot out. And then whatever time was left during the day, then I'd start coming back to review my hearings. A lot of times I'd go home, take care of family stuff, 10:30, 11 o'clock at night, I'd pull my computer out and I'd start preparing. And what I would do is, in general practice before the commissioners, you have a motion, a declaration that supports that motion, which is asking what you want, and then there's usually a counter motion and an objection or response saying, no, we don't agree with that. So what I would do is I would read the motion that's filed, try to figure out what they wanted, I'd write that down. But I wouldn't read the declaration supporting it yet. I didn't want to know the story. I then go to the counter motion, because there's almost always a counter motion, and I would read what they wanted. Then I'd go back and read the two declarations to try to understand the story of this family. So for me, that helped, because if I was reading what they want and then the story, it would start to lean me one way or the other. But then I'd have to try to position myself back in the middle to get the other side, right? So for me, it was just like, I want to know what they both want. Then I'll read the story to figure out kind of where they're at. I would read every single word that was on that form, that was on the motion, up to the page limit. In Utah, we've got page limits for argument and exhibits and whatnot. But I would read every word up to the exhibit. Or the page limit. Yeah.
Prior to page limits, it was pretty important for me, at least, to do memos. So I would really want to have the law, and I would really want to explain the law, which in my mind was really important. But after pay limits, I realized these commissioners know the law. They know it better than anybody. They don't need to be educated in the law. What they need is the facts to help me persuade them into the subjective reasoning of why they make their rulings. And so it's become a really important art to understand how important a story is, like you said, in making sure that it is filling the elements of the law that you already know in your mind. I want to know this because there are lots of attorneys and they do lots of different things. Like, how different were pleadings when it came to the specific attorney that was writing them?
Oh, they were all so different. I mean, you have some attorneys that just aren't very organized. You've got some that you wonder if English is their second language. Some that were super detailed. Some that were going to hit that page limit every time, whether they needed to or not, and just include a whole bunch of extra stuff that wasn't necessary. There was just a wide range. And the thing for me that would get annoying is, when I started working for Bob Echard in Ogden, Utah, and he'd already been, when I started for him, he'd already been doing this for 30 years, doing everything. And he always was just so emphatic about make your best argument first. Get to the point, keep it simple, and just get it done. And I can't tell you how often you'd be reading these pleadings, and I'm just like, okay, what do you want? Where are we going with this? And it's just all this extra stuff that they think that the attorney thinks the client wants in there. And the client really wants, it's important to the client that the court know that this guy is a scumbag or she's a cheater or whatever. Well, yeah, we get it. Okay, let's move on. If it's not actually germane or pertinent to the issue you're trying to talk about, the court doesn't care.
Right.
It doesn't. I don't know of anyone that does. If this is not going to help the court actually make a decision, don't put it in. It's unnecessary.
Right. And I think that that's been a really one way that I've developed my practice is really setting expectations for clients because they, we say, okay, let's write your declaration, and they'll send us 40 pages of just nonsense. And we are like, we pull out, the 6 or 7 sentences that are very, very important, and they get really angry or frustrated with that.
Well, I think too, when you explain to them, and I explain to people too, I want you to give me that 40 pages. I want you to give me everything. But you're paying me all this money so that I can pick out the parts that I know are the important parts the court wants to tell your story.
Yeah.
So give me everything, tell your story. I think they feel good when they tell their story.
Yeah.
But then I'm going to use what I need. But I need the whole 40 pages so I know what I need.
Right. And I have always, before I started Coil Law, I worked for some, very intelligent, prestigious attorneys who taught me that pleadings matter. Yeah. And I have always wanted to elevate our pleadings at Coil Law, and the fact that they say what we need, and they are very to the point of exactly proving the elements, again, to then argue the subjective and argument to the court to get what we want for our clients.
Well, and I think too, in Utah and maybe in other courts and states, in other states that have similar type courts, it's one thing to file your paperwork and go in front of the commissioner on initial hearings and throughout the litigation. When some of this extra stuff matters, citing the law and the memo and stuff, that's when you're doing your trial prep and you're going to trial, and you need to do a trial brief because your judge probably got hired, got appointed to be judge after spending 20 years in the prosecutor's office, and all they've ever done is criminal, which is a lot of them, and nothing wrong with that because they're used to trials. They just don't know anything related to a number of areas of law, and so then they have to be educated. You don't necessarily need that in the front end with commissioners once they've been there for 6 to 9 months.
Yeah, well, and usually commissioners have been doing family law. Right. I think you are actually a little bit more of an anomaly where it was just a piece of what you did. Yeah. Whereas most commissioners, this is their job. Whereas judges, we just had one judge appointed who was a commissioner, so he has probably the most family law experience on the bench. But other than that, it is very rare for us to have a judge that said, oh, I did family law. Just like you said, they've worked at the big law firms doing civil litigation or insurance, or they we get a lot of attorney generals. We get a lot that have worked at the public defenders or the prosecutors. And so when we finally go to trial, it's that's the time, just like you said, an education is needed. Right. In Texas, these family law judges, they're appointed the same direction, but they know family law very well. And so it's not necessarily a matter of education. It's a matter of prepping your case. And so I do feel like Utah is a little bit, trial is expensive here.
Yeah, it is.
And it's because of that. We have to go the extra mile to make sure that we are prepared, to make sure that the judges are prepared, because the judges make mistakes here.
Well, everywhere. Judges make mistakes everywhere.
Yeah.
But I think if you have a majority of judges that don't have the background in the law we practice, it's the job of the attorney to help educate them to understand.
Yeah, absolutely. So how much do you feel like the pleading mattered in your rulings to the argument?
Okay. And I got this question a number of times as a commissioner. The pleadings were probably 75% of importance, and the argument was 25%. So I would review the pleadings, and I'd go through what both parties wanted, and I'd read the story, and I'd take my notes and kind of have an idea of where I thought that it was going to go in my ruling, in my recommendation. Then you'd hear argument, and sometimes the argument was just a recitation of what you'd already read. There was no real emphasis on any one particular point. Okay, fine. I kind of know where I'm going to go with it. Occasionally, about 25% of the time, you'd have argument where, I read something, but this attorney's making this kind of their focal point of their argument. So I would have to stop and think about it for a minute and kind of analyze my notes and kind of flip the papers again real quick and kind of think about, okay, they're making such a big deal about this. Is this a real important point? And do I need to think about it a little extra? Mm-hmm. And I'd think about extra. And there were a number of times where I went in thinking, I know exactly where this case is going. And then after argument, and what I would do most of the time is after I heard the argument, I'd take a short recess, I'd go into chambers, and I'd think about it. I'd want to try to think and make a good decision. It would kind of always bug me when judges or commissioners would, after hearing you argue, would just make their ruling. Mm-hmm. Because did they think at all about my argument? Did they already just, I don't know. I mean, nothing against it. I mean, everybody has their way of doing things.
Right.
And maybe they're just a lot quicker than me in changing their mind or making a decision.
Mm-hmm.
But I just felt like, for me, I needed that little extra time. Maybe it was 2 minutes, maybe it was 10 minutes. And I know that the dockets are full, but I also hope that litigants that were sitting there realized, no, he's back there, he's thinking about it, and he's going to come out with a well thought of, response.
Yeah, and I know that I always appreciate that, because that's exactly what I could at least infer on my clients is he's thinking about it.
Right.
And that means a lot to him. As a practitioner, somebody that's does high litigation, divorces, and, we're going to court on these very, very highly contentious issues. A lot of times it was ensuring that our clients felt heard,
right,
and then listened to, which came into your part. And I agree that there was some times when I felt like a commissioner just came in, had their decision, so they didn't want to hear it. There is some commissioners on the bench that do this, and they already want their decision to kind of be made. And even if the client kind of gets what they want or doesn't, they just walk away feeling deflated, like they didn't get heard. And I think that that's a really important thing. At the end, before winning and losing, it's just being heard and listened to.
Well, and I think, and I 1,000,000% agree with that. And I think what's frustrating sometimes is there's a lot of people that are in the profession that some, and outside as well, but kind of feel like it's if we have this issue, then it should always be resolved the same way. Mm-hmm. And what I would always try to explain to people is, in family law, like other law, but in family law, there are various issues that the issues are always the same. Is there a custody issue? Is there a child support issue? Spousal support, debt division, all those different issues. They're all the same issues in every case. Mm-hmm. But the difference is, what are the facts that inform us as it relates to those issues? And in every single case, it's different. And so while I was there, I probably annoyed people somewhat, because in different committees I sat on and different public events, I would kind of go against the grain and say, look, we can't just push these through like a cookie cutter like factory. Like every case is a little different, and we've got to address them that way. In some cases, we should be able to get through it really fast. Other cases, we need to maybe get some sort of little agreement or temporary order at first, and then let it simmer and see how it works. And I tried to explain to people, you might have one, like me and my wife. Let's say for the last 9 months, I thought, I'm going to divorce my wife. And I've kind of planned for it, and I've kind of started moving things around because I'm ready. I've emotionally gotten to that point. I'm done. But let's say my wife has no clue. She thinks everything's going okay, no big deal. And all of a sudden, she gets hit with the divorce papers, right? And now you've got individuals in different, thoughts of opinion on this that want to just speed the whole process through, when she's kind of in a position where, like, I thought everything was fine. Now I got to figure out custody and, and work and everything. And it makes no sense if you're trying to actually help the people involved.
Yeah.
It's not a faceless situation. It's not like a contract where you're this company and this company, it's faceless and black and white, blah, 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 we're done.
Yeah.
It's actually people's lives, and there's children, and how do we deal with it? And that's what, it wouldn't keep me up at night, but it's what I would think about as I was reading these papers, reading the pleadings, what's going to help these people move forward in this process.
Yeah, absolutely. And I say that all the time, that, you can't settle a divorce until both parties are emotionally ready to settle a divorce. And sometimes it takes longer. Yep. And I make this comment a lot, like, the difference between $5,000 divorces and $100,000 divorces are not the facts of the case. No. It's literally opposing party and their attorney. And, and there'll be times clients come in and they say, oh, so-and-so, my ex has this attorney, and I just, have to let them know, like, hey, to be honest, this is going to be a fight, and you got to gird up. This is going to be expensive. it's frustrating about that. And in Utah specifically, our laws are not clear cut. It's all subjective.
Right.
Everything we argue here in Utah is subjective. So you can have the exact same facts as the person, your next door neighbor, but you can go into a different judge or on a different day, the same commissioner on a different day, and they had a different breakfast, and you can get a different result. So, you have to expect that. And you have to have an attorney that understands that as well and is really good at being able to understand what is needed at court so that you can, advocate for your client the best way possible.
Well, exactly. I mean, because family law really, and you go to court, it's a court of equity is what they say.
Yeah.
And so they're looking at what's equitable, not necessarily fair, but what's equitable, how do we do this? And really all of those factors come into play.
Yeah.
They really do.
And even we don't have an alimony statute, even our child support, even though we have an actual calculation of child support, gross income in Utah is super convoluted and hard to figure it out. I mean, it's just, there's multiple things that make our cases tumultuous.
Yeah. I mean, and really it would be helpful if the legislature really wanted to make things a little more clear cut. I think they could to a point, but I sat on the Utah Child Support Guidelines Committee, which is even outside of the administrative office of the court. It's actually a legislative committee. Well, not a legislative. It's through the governor's office. So I got appointed by the governor to be on that. And the whole purpose of this committee was to look, analyze, review child support, and look at the tables that we have and how we calculate it, and should we change the rules? Should we change how it's calculated? Should we look at different factors? And you've got all these really good people that are in there that they all want to make a difference and help, but you've got people from the court, you've got people that represent obligors, people that represent obligees, people that represent the Office of Recovery Services, and they're all talking, and I raised my hand, I think in the first or second meeting, and just said, we do need to realize though that while we're working on this, the outcome may be that nothing changes, right? And none of them had really thought about that. But when you look at, okay, everything's more expensive, but our wages going up. So I could easily make a case for, hey, child support should be more because kids are expensive and it's getting more and more expensive. Okay, but then on the flip side, I can make an argument, wages aren't going up, costs are going up, so obligors of child support don't have as much ability to pay it anymore. And so it just was this back and forth of trying to figure out how you do that, right? And it's all subjective, as objective as we tried to get it, looking at various, we had reports from different economists, just all of this stuff. It still came down to, how do you go to the legislature and say, hey, legislator, here's the paperwork, things cost more, but it costs more for the obligors too, so we need to reduce it.
Yeah.
That legislator's not going to go say, hey, guess what? Mostly moms, you're not going to get as much money to take care of your kids. They're never going to do that.
Right.
But also going to the legislature saying, hey, we think the child support should be raised because everything's costing so much more. And that legislator's supposed to do what? Hey, mostly dads, you now have to pay more.
Right.
That's not going to go well for them. So it's all subjective. It's all political.
Oh, yeah.
There's a lot of that. And
I can go on and on about my thoughts and opinions with our child support because, in Texas, it's a percentage of your income and it's not tied to custody. It is what it is.
Right.
And because of that, there's a lot of benefits to that because it takes away, I feel like in Utah, because we're based on overnights, how many overnights, custody becomes way more big of a deal than it should be because they need the money. And it causes a lot more, I think, litigation and stuff like that. So, but then also I agree that our percentages make a little bit more sense because, in Utah we have alimony where in Texas they don't.
Right,
so child support should be a little bit higher there. Whereas here we have alimony. And so we're shift of income. So there's a lot of argument behind it. And I don't necessarily know if there's a perfect way of doing it, but
that's what commissioners have to deal with. Because out of the gate, we need temporary orders to put these parties in a situation where they can kind of sort of survive as they move forward to try to get it resolved either through mediation or trial.
Right.
And so all of a sudden you get thrown at you, hey, here's what he's making, here's what she's making, here's here's how many kids, and then they're fighting over the overnights, like you say. I would, as a practitioner, try to convince my clients, look, do you really want your kids that much? Like, are you really spending that much time with them, or are you just needing more child support? And trying to work that way. Sometimes I had obligors as clients where I was like, look, if you really if you realize that it's about the overnights because this person you were married to hasn't worked for 20 years and now they're going to have to go get a job, and you've got plenty of money, you know what? Maybe suggest, hey, look, I'll continue to pay more child support than what the calculator says, because it's not about that. It's about me having time with the kids. And I had clients that were like, really? Okay. And the case got done that fast. It's just, there's so many different variables on the same exact issues, and every case is different. And so one thing that I've always told people that would come in for a consultation with me is like, here's what I'm telling you. Here's what I think how it should be. It's not going to hurt my feelings if you want to go ask somebody else and get a second opinion. We tell, in medical field, you tell people that all the time. This is as important. So if you want to go talk to somebody else, go too, because you may not feel comfortable with me. Maybe somebody else you'll feel more comfortable with. And I think that goes to, when you're looking for an attorney, you need to have some expectations of what you want. I've had clients that they need a grandpa figure to take care of everything. I've had other ones that need one to, instead of saying, hey, it's going to be okay, figuratively smack them a little bit and say, no, wake up, be a big boy, be a big girl, let's go, and it just kind of runs the gambit. And so I think when someone gets an attorney, you want to feel comfortable with them. Not that they're going to do everything that you want them to do, but that they're confident, you feel good that they'll listen to you and help move your matter forward. Because I won't do everything my clients want.
Right.
Because it's not going to help them.
Right.
And I tell them that. But hopefully they feel comfortable with me to where I'm like, look, you're hiring me to help you get the best situation possible. That's what I'm going to do.
Right. And that goes to another tip that I say, like, I'm not so forthright that I say, go talk to another attorney. What I want people... I
wouldn't always do it, but
What I want people to understand is there's the difference of attorneys that want your work and the attorneys that need your work. And I would be very leery of the attorneys that need your work. So the attorneys that are doing the free consultations, they need your work. They want to get you in the door. They want to sell you on what they need. The attorneys that will just say, yes, we can do that. We can get you that. We can do that. Because the realistic attorneys, the good attorneys, especially family law, know that there is no way in, hell that you're going to be able to get everything you want in a divorce. And so you have to be leery of that. And so my job is, and I've just gotten really good at this, is I set your expectations at the beginning, which is why some people don't hire me, because they don't like what I have to say. But at the end of the day, if you hire me, you better trust me. And then at the end of the day, we're going to make sure that we're advocating for you the way that we know we can best do that. Right. And some people don't like that because they don't think we're advocating for them exactly the way they want us to.
Right.
That's when you need to go find that need attorney, because at Coil Law, we don't need your work. We have plenty of work. What we want to do is zealously advocate for you in the best way that we know how.
Sure.
And
we'd like it, but we don't need it.
Yeah, exactly. Exactly.
But I think that comes with expectations. If I was going to an attorney, I'm giving them money, right? Or if I'm going to a doctor, I'm giving them money to take care of me. I'm not going to go to the doctor and have my phone out on WebMD and tell the doctor, here's what I want. Right?
Some of them try to do that.
I know. I get it. But what I'm saying is I may have looked on WebMD ahead of time of what I think I should be doing or get, right? But then when I go to the doctor, that WebMD article gave me ideas of things I can ask about and move forward. Not here's what it should be. It's the same thing in the legal thing. There's so much information out there on the internet that can tell you this or that or whatever. Sure, look it up and think about what you want to do with your custody situation. But then come to us and ask us the appropriate questions so we can let you know how it actually is.
Right. I absolutely agree with that. So that goes to my next question is, like, on the bench, what information did you find was really, really helpful? And I'll give you an example. So, like, for us, because gross income and net income are very, very important when it comes to child support and alimony. And there's a myriad of ways that people get to gross income. In fact, I would say, and I guess I'm being a little bit hot-headed about this, but most attorneys don't even know.
I need to tell her, chill.
Most attorneys don't even understand gross or net income correctly. But what we would do at Coil Law is we do footnotes to specifically tell the commissioner, this is how we got our gross income, or we'll do it on the financial declaration, which is important for you guys to look at. So I am very, very particular in making sure that the commissioners see how we did the math.
Right.
So you know that it wasn't just a number that we threw out. So that's just an example of something we feel like is information that's really important for you. What would be some advice that you felt like was really important for you?
I think let's stay on the financial situation. It's helpful to know how people calculated it. I may not have always agreed with that, but so what I would always want is the last, a very recent pay stub, the last year's W-2, the tax return. Maybe, but more importantly than a tax return, if someone's self-employed, I want to see their profit and loss statement, and then their schedules on their tax return. If it was a self-employed business, a Schedule C. If it was an S corp, your Schedule E. I mean, because what I want to see is, you talk to people all the time. Hey, how much did you make? And they think about their tax return. Well, I only made $40,000. Okay, time out. You're self-employed. You run a car detailing place. Let's look at your schedule. Oh, you depreciated equipment of $25,000. Well, that's money that stayed in your pocket. That's getting added back in.
Right.
Oh, you had meals and travel. Okay, well, everybody has to eat and travel unless you can tie it into a reasonable business expense. That's gone adding it back in. Oh, you paid for your truck. You've got a nice wrap that advertises. Okay, how much of your truck are you using for personal? How much are you using for the business? A lot of times I would just split that in half to not have to do all the math. Same thing with phone, those type of things. Because our Utah code allows for you to deduct reasonable business expenses, but like so many self-employed people, I'm running my phone through my business, I'm running my insurance through my business, I'm running everything I can through my business because for tax purposes, I can do that.
And so they want to try to turn it around and say, well, for child support, it's going to make me pay less. And,
right.
You guys see through that, which we're grateful.
Right. And so getting those out the gate is helpful. Do I need credit card statements? No. Unless you're specifically tying them to a particular line item, right? But those are important for financial issues. For one thing that's important, I think, in reviewing documents to make a decision, if I have a letter from one spouse's parent that's not supportive of that person, that's helpful. Because 99% of the time, a party's family is or friends are going to write stuff in support of the person. That is not helpful. I know that Aunt so-and-so is going to support, the dad. It's his aunt, or mom, grandma or whatever. But if you've got specifically a parent, and a lot of times it happens in when there's drugs involved. If I've got a dad or, let's say dad that's on meth, right? And dad's mom has written a declaration in support of the mom, not of her son. Right. That is helpful because then it's like, okay, this is real. We need to look at that,
Yeah, I always say, like, with witnesses, it's like your inner circle, so your, like, closest people, those are the least helpful witnesses. Right. It's the next one-armed sphere of, like, teachers, doctors, therapists. Daycare providers, people that are outside your regular, circle of influence, meaning they are going to support you because they love you kind of thing. That is really important evidence to give to the court.
It is.
And I think this is what I'm excited to talk to you about this because we are a high litigation firm and you know that. So the word high conflict, narcissistic personality, high conflict personality comes up in probably 95% of our cases.
Right.
And I want to talk from your perspective of being on the bench of how you deal with those words, how you deal with those terms, because sometimes it's important. Obviously, it's sometimes, but you hear it so much. So I wanted to know, like, how do you deal with it? How important are those words? And what is the information that people really need to be getting to you to make it so that it's not just another...
Well, and I think for me, it would come down to, and like I said, I can't speak for everybody, but for me, words don't mean a whole lot. Actions do.
Okay.
All right. So I would see it all the time. Oh, this person's bipolar, or they're narcissistic, or blah blah blah. And they just go off this whole list of whatever. But then they wouldn't really give much information or facts as to support that quote unquote diagnosis or that description that they're making, right? I don't need to put in the paperwork that someone's a narcissist. I can in 3 little paragraphs say they did this, and this is a constant thing they do, and this is why it affects me, or this is why it affects the child. Boom. I think sometimes we look at those key words as practitioners or as parties thinking, well, if I put that little special word on, then I'm going to get what I want. No. If anything, I think commissioners kind of look at it and go, I hear that all the time, so what? And they don't, and it almost like turns them off a little bit. It would turn me off a little bit, and then I'd have to look okay, where's the behaviors that actually support this, right? I don't need a paragraph, I don't need a sentence telling me they're a narcissist. Tell me what they're doing or not doing. Tell me what you're doing or not doing to support your position. Right. That is more helpful.
Right. And how do you deal with the mom that comes and, they've been married 25 years and there's just been extreme emotional, financial abuse. Sometimes it's gotten physical, but there's never been the cops called. There's never been, that event that, And so now they're coming to say, look at this control, look at what he's done for me. I've never worked because he never wanted me to. But how do you deal with that kind of evidence?
Well, and the hard part with that is it kind of goes back to a person's agency, right? You were there. You were with this person. They treated you like garbage. Why did you stay, right? You don't want to blame the victim, right? But also, there's no evidence that they really put forward because we live in America, right? We have to have due process, we have to have evidence, and so it would be hard. There would be, I'm not on the bench anymore, so I can say this. There would be times where I knew in my gut, I'd get a feeling like I need to make a ruling a certain way, and there wasn't as much evidence as maybe was there. I would make that ruling that my gut said, because if it really wasn't the case, thankfully in Utah with a commissioner system, if it really wasn't the case, they could object, take it to the judge, and judge could correct that if I was wrong. But so often, if there wasn't the evidence, we're an evidence-based system, and so if there wasn't the evidence there, I'd feel kind of bad for somebody, but okay, sorry, this is where we have to go moving forward, and it's hard. It's really hard, and sometimes you can look at somebody and know they're full of it, or they're a piece of whatever. A lot of times you can't. They can present really well. They can present, I'm just this great person, blah blah blah. When you're getting a story that no, they're horrible. They're emotionally abusive. They never let me. They gave me an allowance. I'm a spouse with an allowance. What's that about? Right. And all these problems. You're like, it's probably right, but all I can do is what the legislature says we can do, and these are the statutes we have. And so. It's hard, but that's the only thing you could do is rely on what's the statute say. If I don't have enough evidence, okay, well, hasn't worked for 20 years, now she needs to, And normally, some commissioners would hold someone to, okay, we know you can go and get minimum wage somewhere, right? I would usually, especially the last 2 years with the economy the way it was, be like, well, I don't know of any jobs paying the minimum wage, but I know jobs right now you go get for $12 an hour without any problem. They're not great jobs. I don't want to do it, but they're there, and they can help you. So we need to look at that first. Then let's look at what your needs are and see if there's a spousal support thing on top of that after the child support and that.
How do you, because another problem that we see is that, you have that person that's been emotionally or financially abusive, maybe not physically abusive. Right. And obviously, I'm always like, well, great, divorce them. That's the best part about divorce. You get rid of that. But it bleeds into them then creating this narrative that because that person did that to me, therefore they're a horrible dad or a horrible mom. They don't deserve custody or parent time. I want all the controlling decision making. I want, them to have as little time as possible. As a commissioner, what is some advice that you can give these people to that? Because my biggest thing is even if they got minimum time, they're still getting every other weekend with their child. I mean, they're still spending, time in chunks with these kids. They get 4 weeks in the summer. I don't know how you get exactly what you want when you are so adamant on getting minimum time.
I think part of it comes down to a knee-jerk reaction to what's been going on for so long, right? Where you've got this mom that's been controlled and treated poorly or whatever, finally recognizing it and realizing, you know what, I'm taking my power back. And this is what I want because this is how you were for the last whatever, right? What I've tried to do either on the bench or in private practice is kind of explain, that, well, don't you want dad to do the homework with the kids? Mm-hmm. Don't you want him to change the poopy diapers? You said that he's a Disneyland dad because you've been doing everything and that's how you guys had it, right? But don't you want him to have to do it? Don't you want to have some time away to where you can do your own thing? Most moms want that, not all. And then you try to just say, look, the legislature has given us these different guidelines. And based on what's been provided, as much as he was controlling now, that's not going to be the way. But the kids still get to be with dad.
Yeah.
And one thing that I would try to explain to people, and I did this earlier on than after, and then occasionally if I kind of felt the gumption to say it, but there were times where I'd look at both parties and I'd kind of point at them and say, I don't care about you. And I don't care about you. Mm-hmm. And they'd get these looks on their face like, what did I just walk into? And then I'd pause for half a second. Like, I care about your 9-year-old daughter and your 11-year-old son and what's going on with them. And so this is why I'm going to make the ruling that I'm making on a temporary basis. Yeah. And, kids need to be with dad. And I'm going to rule that they ought to be with dad, every other weekend plus an overnight during the week, which isn't a lot, but here's why I'm doing it. And dad, the kids are going to be with you. You're going to do homework with them. Mm-hmm. You're going to do things other than just play games. Yeah. And it's really hard, but you first hope that an attorney is sharing that information with the client with the expectations. Like, I know you want everything, but here's where we're at in Utah. And right now in Utah, I remember reading a case, 14, 15 years ago from a little bit earlier, where the appellate court in Utah said, hey, everything being equal, moms ought to have the kids. Boom, and just gave mom everything. Yeah. Right? And now the pendulum is swinging. It's almost swinging too far the other way and not in the middle, trying to almost compensate for that prior. And I don't think that's a good thing either. Right. I think the legislature, in their wisdom or lack of it, have provided the statutory guidelines to allow judges and commissioners to kind of see the whole picture and try to do what's in that kid's best interest. Yeah. And sometimes it's a 50-50 situation. A lot of times it's not. Yeah. Because for me, the big picture is what's the best thing for those kids? I don't care what's in the best interest of those parents. They're adults. They should be able to deal with it, right? And I'd make a ruling sometimes and I'd get an attorney, well, maybe that's going to be inconvenient, Your Honor. And I'm like, I got 5 kids. My entire life is inconvenient. Yes, okay? That's part of having kids. Yeah. And so there were times, a lot of attorneys that would come in, not a lot, but there were a number of attorneys that would tell me, I can predict what Commissioner so-and-so is going to do pretty accurately and this other one, but for you, it's been kind of hard. And I would pause and say, well, did you think about the kids in that situation? Because I'll bet if you thought about the kids, it was easier to predict what I was going to do. Yeah. And they're like, oh. It's like, that's the whole point. Mm-hmm. You've got, adult clients, sometimes you need to kind of help and baby step them a little bit, but it's those kids that need the help. Yeah, absolutely. They're stuck in the middle of everything. Yeah, this has been so good. We have to wrap up. We're running out of time, but I almost feel like we need to have a part 2 because I feel like we can really talk and dive into a little bit more best practices in front of commissioners because I think this is really good for our listeners, even because they need to hear it. And getting the perspective from the bench and then the perspective from the attorney, I think is really, really important. Yeah. So just like as a final thought, like what is like maybe your top tip that you would always kind of like want to just leave out there for people going through this situation? Like for in court or just in life in general?
Yeah, I guess either way. I've heard you talk at a lot of CLEs and kind of talk about your tips from the bench and what you want from an attorney's perspective. Right. But maybe because most of our listeners are are those people sitting in those seats.
Right.
Maybe your best tip for them.
My best tip for them would be to do everything you can to keep the kids out of the middle of the situation, right? Kids are going to ask questions. They're going to want to know stuff. What they need to hear is that you're working it out and things are going to be okay.
Yeah.
That is so helpful because when kids feel comfortable, they're not positioning themselves to try to survive. When kids know that there's chaos and problems, then what's happening? They're going to mom and they're telling mom exactly what mom wants to hear so they can survive in mom's house.
Yeah.
Mom hates dad. Okay, I'm going to hate dad right now. They go over to dad's house and dad hates mom. So what am I going to say? Oh, yeah, I don't like mom either. And what that does is it actually creates more litigation and problems between the parents because now these kids are in the middle of it and they're believing everything the kids are saying when the kids are just saying things to survive.
Yes.
Like, mom, leave me alone. I'm fine how things are. Just let me, I know it's not my fault. Just you guys deal with it. Most kids just want it to be done and over with. And the more parents realize that. That's why I think there's some practitioners that want to try to speed the process up. Kids are in the middle of it. Let's get it done to help them. Great. But we've got to get it done in a way that's the most beneficial for them and not just speed it through. So that's my biggest tip is just try your best to keep the kids out of it. Take what they say with a grain of salt and move forward that way.
Yeah, absolutely. Remember, no one dies from divorce. I mean, this is what we do and why we're a little bit different at Coil Law, because we're not there just to say yes and do what you want, but to help you navigate through this process that is going to be very, very challenging. And it's not necessarily always going to tell you you're going to get what you want, but it's helping you understand the expectations and then giving you that advice to recognize that you can do this, that you can sit in this and you can become a better version of yourself. And it's not going to be easy. Nobody wins in divorce.
No. Well, my final statement is when I first started working for Bob Echard right out of law school, one of the things he mentioned to me as you meet with clients is, yeah, you're an attorney, but you also should be an attorney, or not attorney, but you're an attorney, but you should also be a counselor at law.
Yeah.
And I think a lot of attorneys nowadays have forgotten that.
Yeah.
And I think that's why I like being here, is we're actually trying to help people better themselves and their situation.
Absolutely. Thanks, TR. Thanks for joining us. I really think we'll have a part 2 on this. This was really helpful. Okay. So till next time, no one dies from divorce.
Go Utes.
Thank you for listening to this episode. If you enjoyed, please subscribe, follow, and share. I'd love to hear your questions and feedback. You can contact me at community@jillcoil.com. See you next time. I am an attorney, but I am not your attorney. Any advice given on the podcast is general and shall not be construed as legal advice.